Reflections on the Roberts Court is the right way to put it. It was going to be a talk, a prepared talk about the Roberts Court until I became an Ebola expert 10 days ago, and that's been keeping me busy so that I haven't been able to render this as more than notes, so I hope you'll bear with me, and I hope I won't be too unbearable. But the Supreme Court and its role in American life, American politics, is to me fascinating. I was talking earlier with one of the students, one of the fellows in the program, about why I like writing about the Supreme Court, and it really is that for someone who's covered a lot of presidential and legislative politics over my career, in those stories you are always aware of the fact that what's really going on is out of view. You go to the Congress and you sit up in the press gallery and you look down and somebody's giving a speech to the camera or something, but you know that the real action is going on in an office somewhere or a restaurant back room or something. And similarly with the White House, there's the big fence around it, which until recently nobody could get over. And inside there, lots of important stuff was going on, and it was very hard to figure out. The court is not like that. They look at the cases, and then they spend a lot of time writing down what they think about them and why they think that. And so if you're willing to invest the time to read their opinions, which a lot of journalists are not, you can figure out where they're coming from. And I think that's a good thing about this very powerful institution, is that in that way, it's very transparent. They say what they think and they explain why they think it. Nevertheless, it is a political body, and we're aware of that, and so we'll talk about that a little bit. But I want to start with the idea of a Roberts Court or a Rehnquist Court, a Warren Court. In 1980, when John Roberts had just graduated from Harvard Law School, he clerked for then Associate Justice William Rehnquist, who later, of course, became Chief Justice of the court. And one of the assignments that Rehnquist gave him, which it's always intrigued me why Rehnquist did this, whether he had a crystal ball, but he assigned this bright young clerk to write an essay on the power of the Chief Justice. What exactly can a Chief Justice do and not do? And Roberts came to the conclusion, influenced by an essay that Felix Frankfurter had written, the great justice of the 30s, 40s, into the 50s, that really the Chief Justice doesn't have much power at all. Frankfurter's line was that each justice is his own sovereign, and that was where Roberts came out. And flash forward, a generation, and Roberts himself was being nominated for Chief Justice of the Supreme Court, and he made certain promises about his ability to lead the court, and I'd like to sort of piece through exactly how well he's done and in what sense it's become a Roberts Court. But first, in the spirit of Justice Frankfurter, that each justice is equally powerful sovereign, just a few thoughts about what the Supreme Court is, how it works, and who the members are today. We now have a Supreme Court that is more diverse in terms of how they look than we've ever had in our history. We've got 3 women on the court. We have an African American on the court. We have a Hispanic on the court. They are less diverse, arguably, in their backgrounds, culture, how they think, how they're trained to think, than we've ever had before. For most of our history, presidents, if they gave any thought at all to who they were going to put on the Supreme Court, it was very idiosyncratic how they would approach it. Sometimes they put their friends and advisors on the court. Roger Taney was a close advisor to Andrew Jackson. Abe Fortas was a political, advisor to Lyndon Johnson. We've had a lot of law professors, Frankfurters, when we had a lot of distinguished lawyers coming straight from private practice onto the court. The great Louis Brandeis followed that pattern. More recently, Lewis Powell, excellent justice from Richmond, came on the court directly out of private practice. We've had a former president. We've had state court judges that nobody had ever heard of, William Brennan. We've had government apparatchiks. William O. Douglas was running the Securities and Exchange Commission. We've had people that presidents needed to get out of public life. Salmon Chase was made Chief Justice of the Supreme Court so that he wouldn't run for president against Abraham Lincoln. We've had a lot of political payoffs. Earl Warren delivered the state of California for Dwight Eisenhower in the 1952 election, and his reward was to be made Chief Justice of the Supreme Court. So all this diversity, all these different state court judges, Brennan, Sandra Day O'Connor. Now we have only one kind of person on the Supreme Court. They are all graduates of a tiny handful of law schools, Harvard, Yale, or Stanford. For diversity, we go all the way out to the West Coast to Stanford. They have, all of them have then gone to be clerks in the federal court system, and then they have gone to work as promising government lawyers. And then the next step in their lives is a little bit of diversity. A few of them become maybe law professors, and but not interesting law professors, very uninteresting law professors. But most of them are government lawyers in a certain number of jobs. The White House, counsel's office, the Office of Legal Counsel in the Justice Department, the Solicitor General's office. These are all places where eggheads go to think deep thoughts about the nature of the law. And they are not places where people go to have interesting life experiences. And then in almost every case, they're appointed to the federal bench, not to a district court where they would meet real people and try cases, but to appeals courts where they will sit in panels and think together, reason together, and then lock themselves into rooms by themselves and write. It's a kind of a legal Vatican almost, where people come into the seminary and are protected from life and gradually developed over time into bishops and then cardinals, and one of them becomes the Pope. So the only diversity that they have then is a philosophical diversity, in that some of them are conservatives and some of them are liberals. All right. That too is a pretty modern phenomenon. It was created by a thing that used to happen to presidents because they wouldn't really pay much attention to their Supreme Court appointments. Sometimes they would appoint somebody who would decide cases very differently than they thought they were going to. The Republican Eisenhower creating the Warren Court. Or you get the Republican Nixon, who was famously paid no attention to who these people were he was putting on the court. I mean, he put Justice Blackmun on the court because he happened to be a boyhood friend of the Chief Justice Burger. They just knew each other, you know. I got a guy, he could be on the Supreme Court for you. He nominated Rehnquist when somebody told him, well, why don't we appoint that guy over in the Justice Department at OLC? And Nixon said, oh yeah, Rynchburg, let's put him on the court. Didn't even know the guy's name. They didn't interview them. And Blackmun, went and wrote Roe v. Wade, and as recently as David Souter, appointed by the senior President Bush, these Republicans would nominate these guys and they'd go all squishy when they got on the Supreme Court. And there was a vow that was never going to happen again. And so on both sides, we now have people who, from the time they're identified as these highly promising individuals, they are never allowed to say anything that might damage their chances of being confirmed someday. They're never allowed to write a controversial paper. They're never allowed to express the idea is that we're going to develop these hothouse flowers and someday they will blossom into Supreme Court justices. That sounds highly critical, and in many ways I mean it that way, but I also want to say that it has produced a phenomenally intelligent, well-educated, knowledgeable, disciplined group of judges on our Supreme Court. There is not a weak mind or timid thinker or follower on the entire court. They all think for themselves. They all are brilliant constitutional analysts. They all write, their writing ranges from middling to excellent. There are no muddled thinkers. The caliber of the Supreme Court is extremely high. But imagine if you're the Chief Justice trying to lead that group of people, trying to influence it. That's page 1. How has John Roberts approached this? We talk about the court as being, and I did it myself, conservatives and liberals. There's 5 conservatives and there's 4 liberals. That's the way we kind of divide it up for our shorthand. And they do divide out that way on a lot of opinions. They come out, the 5 conservatives against the 4 liberals. But they're not as exactly the same as you might think. Among the conservatives, for example, you have some really different breeds of cat. You have Clarence Thomas, who is a radical in his conservatism. People don't read Thomas's opinions, but if they did, they'd be amazed that this man is on the Supreme Court of the United States, not in the way that a lot of people think they're amazed, but that a guy who is so radical in his thinking on certain subjects, especially race, ever made it onto the Supreme Court. He's fascinating justice, but he doesn't agree with even his fellow conservatives on a number of key points. Then you have the bomb-throwing ideologue that we all love, Antonin Scalia. Brilliant writer, genius mind, acerbic, funny, vicious, violent. Then you have Samuel Alito, who is every bit as smart as Scalia, but personality-wise, completely the opposite. Shy, polite, infinitely polite, conciliatory in a sense, not giving up on his ideas, but wanting to get along with people, wanting to be civil, wanting to hear people out. Then you have Anthony Kennedy, who is a whole different breed of cat. He's a libertarian, not a classical conservative. And then you have John Roberts, who is an old-fashioned conservative, and by that I mean 18th century conservative. At Harvard, when Roberts was an undergraduate there was a brilliant senior faculty member, the greatest literary biographer who's ever lived, named Walter Jackson Bate. And Bate was both, he was eccentric. I met him one time and he had on 3 different watches and they were all set to different times. So none of them were keeping the accurate time. And he would look at them. He had a lit pipe in his pocket and a cigarette in his hand. But he was a great teacher of undergraduates, which is kind of unusual for some of these equally great critics. He had an enormous impact on generations of English students. My mentors as an English student were students of Bate, and I was amazed when I met Roberts to find that John Roberts had come under the spell of Jack Bate when he was an undergraduate. Bates' greatest book was a biography of Samuel Johnson. Most of you probably know that name, but this was the great mind of English letters in the 18th century. A stunning genius, a man, he compiled the first complete dictionary of the English language by himself over a span of 7 years. He got the idea from the French, who had had a committee of about 170 people do one, and it took them about 35 years. He said, I could do that. Johnson was an essayist, a poet, a novelist, a dictionary writer, a critic. And Bates' biography of Johnson has been called the greatest literary biography of all time. John Roberts had a particular work by Johnson that captivated him. It's a long poem called The Vanity of Human Wishes. And it is as dark a poem as you can imagine. And the basic idea of it is this classically conservative notion that the best laid plans of mice and men, will swiftly go awry. That no matter how hard we try, we are basically flawed and we're going to screw up. And so the kind of classic line about, he says, protracted life, life protracted is protracted woe. That is sort of the germ of the poem. It's the vanity of our best wishes. It's all going to come to dust. Roberts likes this poem so much that he reads it every New Year's Eve. Sits down in his house, this handsome, wealthy man, the Chief Justice of the United States at the age of 52, or wait, at 49, I guess, with a beautiful wife, beautiful kids. He reads this poem about how badly life sucks and how doomed we all are. It's a great image. I picture him in his mansion in Chevy Chase, with his big leather chair with the fire crackling and, a glass of expensive scotch, and, life protracted is protracted woe. But it gets at this germ of the old-fashioned conservative idea that you want to be very careful about reforming things, about launching big projects, about taking over the healthcare industry, about whatever, because it's probably going to go wrong. That's that classic conservative idea. That's where he comes from. But it's not an antagonistic conservatism almost that you see in a Scalia. It's not a radical conservatism. It's a friendly conservatism almost, you know, that I'm going to screw up, you're going to screw up, we're all going to screw up. And so let's be very careful. Let's take baby steps. That's where he was coming from when he was nominated to the Supreme Court of the United States. He found this institution, and conservatives of his type love institutions because they have more time to fix their mistakes over time, you know. This great institution that he loved, that he had been really a part of since he was a young man, he was nominated to become the Chief Justice. Every prospect that he would serve a very long term, and he found this institution in crisis. Why? Well, because he would say, probably, I'll say it, over the previous generation, the court had been taken into realms of American life that it had never gone before. It had produced some results that I think everybody in the room is deeply proud of. Brown versus Board of Education. Desegregating the schools. Striking down the old death penalty. One man, one vote. The right to counsel. Even Roe v. Wade, more controversial, but you know, the court had always been political, but now it was political in the very center of people's lives. The actions of the court over that period became not just important in people's lives, but symbolically powerful in their lives. You know, you might never try a death penalty case, you might never have an abortion, but you had feelings about those cases, and they symbolized things to you about the way society was going, either good or bad. The court was right in the middle of these very charged issues. The personalities being put on the court became more and more important to us in the public. People who had never heard of you know, Stanley Minton, you know, they knew who Harry Blackmun was, and they knew who Bill Rehnquist was, and they knew who William Brennan was, because they felt this real centrality of the court. The appointments of the justices became more and more politically charged. Televised confirmation hearings, some of them very dramatic. Take us back to the 80s, the speech that Edward Kennedy gave that basically destroyed the appointment of Robert Bork in 1986. Hugely dramatic and personal and intense. This court, which was seen more and more as a tool of the parties, was thrust just a few years before the Roberts nomination, totally unexpected, totally unprepared, directly into the center of the most important political process that we have, the choosing of a president. With virtually no time, these people, justices, are used to working over periods of months to weigh issues and decide cases and make sure they're properly briefed and properly research their opinions. And here was Bush versus Gore that needed to be decided within a matter of hours. And it was decided. And it was decided along that 5-4 split, where the Democrats voted with the Democrat and the Republicans voted with the Republican. It was the worst possible optics. The credibility of the court was damaged in a way that it hadn't been in 100 years, probably, since Plessy versus Ferguson. This is what Justice Roberts was walking into. And he set for himself the task of restoring some of the credibility of the Supreme Court. And for him, as this conservative, what that really meant was to bring the court back out of the center of America's political life, to dial down the expectations a little bit, to create a more constrained relationship with these other branches of power, the presidency and the Congress, to get the justices dial down the temperature of their rhetoric and their disagreement, to try to have fewer 5-4 decisions and more 9-0 decisions. This is a pretty ambitious agenda he set for himself. And when I first wrote about it in 2007, my conclusion was that he wasn't making much progress. The 2007 term had been just lights out with the personal vitriol that the justices were putting into their opinions. You know, oftentimes over very small cases. I talk about one that even Roberts himself participated in. It was a case involving a few hundred students in one school district, and it was about whether these students could explicitly be identified by race in the process of deciding which school they should go to, because the district was trying to have integrated schools in spite of the fact that it had segregated neighborhoods, you know, life that a lot of us live with. So it's just a few hundred kids. It was a pretty clear-cut case. Something similar had been decided a few years earlier. It had gone this way. The tradition would suggest that if it's been decided that way once, you should decide it that way again in the next application. One side won the case, the other side lost the case, and both sides rolled out these cannons of bombast and rhetoric about the racism of the other side and the death of Brown versus Board and the last days of the Republic. And it was just ridiculous what was gone into this opinion of hundreds of pages devoted to this. I noted in the case that the so-called great dissenter in the history of the Supreme Court, Oliver Wendell Holmes, his dissents were typically from 1 to 3 paragraphs long, and he would generally start or finish by saying, "I greatly regret that I cannot join the majority in this case." You know, very deferential, polite, explain his objection quickly and get out. You know, now these dissents were occasions for hand-wringing and operatic. But now, 7 years after that, starting Justice Roberts' 10th term, I've come to a different view. I think he's genuinely making some progress at the court. Last term, they had more unanimous opinions than they've had in years. And how's he done that? I'd just like to talk a little bit about that. Well, first, we have a little less bombast, and he has led the way with that. He doesn't do it quite as much as he used to, and he likes it too. He's a good writer. He thinks he's an even better writer than he is, and he really likes to pour it on when he thinks he's got the winning hand. But he's dialed that back some in his own work. Time did not Time magazine, Time, the March of Time, did this, the rhetoric of the court a big favor when Justice Stevens retired and he was replaced with Elena Kagan. Justice Stevens had sort of adopted in the late years of his career the role of the anti-Scalia. They had been, Scalia is a brilliant writer and just so mean and wonderful and catty and slashing in his opinions, and he gets great joy out of it. And Stevens had clearly decided that there needed to be somebody on their team, on the liberal team, giving it right back to him, and he had taken on that role for himself. And Justice Kagan is 100% the opposite of that. She's every bit as smart and really much smarter than John Paul Stevens, but she is, well, she was dean of the Harvard Law School, and successful dean. And for those of you who know the Harvard Law School, that's all you need to know about her diplomatic skills. Anyone who survives that job intact is ready to be Secretary of State. I mean, it's just a viper's nest of brilliant and hateful people. And so she's lovely, and she's smart, and she can make her points just as effectively with a smile as she can with vitriol. And so just that trait alone has helped with the mood of the court. Well, I was started to say that Scalia maybe is mellowing in his old age, but I don't think that's right. I wouldn't want to be taped saying that. But there are things that are, I think, Robert's work that are also playing a role here. The way you get to unanimous cases, 9-0, on a court of, these brilliant hothouse flowers, these, is not by changing anybody's mind, Nobody is going to walk into Ruth Bader Ginsburg's office and talk her into deciding the case differently than she thinks it should be decided. And the same is true of all the other 8. I just picked her out. These people have arrived at their opinions based on years and years of study and thought. And they're not lightly held, and they're not easily moved. So that's not how you do it. How you do it is by persuading them to write their opinions narrowly rather than broadly, to decide the very narrow questions whenever possible that they can get to agreement on, rather than expanding the decision to a point where they can't agree. Now, obviously, that's not going to work on every case, but there are cases, we found out last term, more than we realized, where that can work. And this is attached to that idea that Roberts has been promoting of the Supreme Court dialing down its sort of view of itself and of its role. It's not necessary to decide controversies before they're ripe. And you don't have to decide every issue in a case to decide the case well enough to get along to the next term. Next term, there might be a better case that frames that other issue in a brighter light. Or, by next year, the controversy of this year may have gone away. We've seen that, I think, very recently, just last week, in the way the Supreme Court has handled the issue of same-sex marriage. Now, those of us who cover the court were very excited to have these opinions coming out of the courts of appeal striking down laws against same-sex marriage all across the country, because we thought, well, this is going to take this bombastic issue that will surely get me on the front page or on the cover of the magazine, and it's going to get it right back in the Supreme Court for the final blow. This is we're something more exciting than a land use question to write about next week. Instead of taking one or more of those cases and using it as the opportunity to pronounce for the country, yes, we've finally arrived at the point where every American has the right to same-sex marriage, they looked at this in a way that we haven't seen a Supreme Court act in a long time. And they said, there's no controversy here. These courts of appeal are all arriving at the same outcome. We only need to step in when one court of appeals says this and another court says the opposite, and then somebody's got to sort out what's the controversy, what's the right answer. In those cases, the Supreme Court is needed. But if these lower courts are all arriving at the same point, then we're not needed right now. And so they simply didn't take the appeals. People in my line of work were shocked. It's like, what does this mean? Well, it means that the Supreme Court has taken more of the John Roberts view of its role in the system. Its role is not to pronounce from on high how should we live as Americans. Its role is, as he famously said in his confirmation hearing, to be the umpire, to call the balls and strikes. You know, on the balls that are hit over the wall, the umpire doesn't ever call those. It's just when the umpire is needed that the umpire steps in. I think that's what he meant by that. And I think we've really seen in that instance how it works. And finally, he, in probably his most famous case so far, he's used his own vote strategically in order to present a vision of compromise as opposed to a voice from the extremes. And I'm talking about the Obamacare case of 18 months ago. Here was an instance where the Supreme Court was being asked to take a very, very prominent role in our system of constitutional democracy. The Democratic proponents of the Affordable Care Act were essentially asking the court to bless it as 100%, no problem, nothing wrong with it. The Republicans were asking the court to take this law that had been passed by the Congress and signed by the President of the United States and strike it down. Those are two very large roles for the court to take. And 4 of the justices were ready to take on one of those roles, and the other 4 justices were ready to take on the other one of those roles. And Roberts crafted what is, to me, a remarkable decision. I'm not sure it's a good decision from public policy standpoint. The issue is much too complicated for me to say. I'm not sure it's a very constitutionally sound decision that anybody's going to be teaching in con law for years to come. But as a decision by the leader of the Supreme Court to try to preserve and protect the reputation of the Supreme Court, to draw it back away a little bit, step by baby step, from its central role in our politics, symbolic politics. I think it was a brilliant opinion. I won't go overly into the details, but he basically agreed with his liberal colleagues on half of what they had to say, and then gave his conservative colleagues half of what they wanted, and he let both sides write their dissents denouncing him, and he gave this law back to the branches of government that are charged by the Constitution to decide questions about how we regulate commerce and industry. It's not the Supreme Court's job to set health policy in the United States. Those of us who read and respect the Constitution, I think, understand that that's not really what they were conceived to do. That's the Congress's job, that's the President's job to execute the law that is created. That's a political process, and Roberts restored it to the political process. Where it is remains to this day, and I predict it will be a lively point of debate and discussion for years to come. So these are the reasons why I've come around from thinking that he was perhaps failing in a hopeless job to thinking that he is making progress in a very difficult job. He's 59 years old now. His ticker, which was in question, seems to be going along just fine. He could easily be the Chief Justice for another generation. And I think if he is, will certainly be enough time to render a clearer verdict. But, you know, contrary to what we learned from the vanity of human wishes, I'm actually a little bit hopeful that he is going to wind up leaving quite a positive legacy on the reputation of the court. And I'll leave it, I thought I'd finish just by saying a couple of words about the term that's coming up. So far, and this would delight Chief Justice Roberts, it looks like a pretty boring term, which again was one of his goals. But if you look at what are going to be the sort of easy to understand and discuss cases, I think you can see some of his philosophy about what the court needs to do showing through there. There's a case called Elonis versus United States, which is a case where a really disgusting and reprehensible individual was posting horribly violent, vivid threats on his Facebook page about things he was going to do to his wife and the cops who were taking her side in their family disputes and so on and so forth. And he was arrested and charged with, I assume, assault, and convicted, and he has appealed his case all the way up to the Supreme Court, saying that, no, doing this kind of thing that you couldn't do in this room, I couldn't threaten you endlessly about all the things I'm going to do, cut your head off, beat you to death, feed you to a wood pulper. But by doing it on Facebook, it's kind of like rap music or a violent movie. It's protected speech by the First Amendment. It's not enough to say that you're threatening. You have to prove that he actually intended to go out and do these things. All right, so that's and why I think taking that case on appeal is interesting is because this is a new question. The internet is producing these new First Amendment questions, and so it's not something the Supreme Court has done before. It's not something where the law is clear. The famous dictum from the first important Supreme Court case, Marbury versus Madison, that the job of the Supreme Court is to say what the law is. This is a classic job for the Supreme Court. What is the law on this new fangled thing? Another example, classic what the Supreme Court is for kind of case, Zivotofsky versus Kerry, is an instance where it has to do with a American citizen who was born in Jerusalem, and the question, which you can see why it would be interesting to some people, is that he would like for his passport to say he was born in Israel, not Jerusalem. Well, why is that an interesting question? Well, because for many, many years, the United States State Department has very explicitly and carefully avoided saying that Jerusalem is in Israel. The question of the status of Jerusalem, very important to Israelis, very important to many American Jews. The State Department doesn't want to touch it with the proverbial 10-foot pole. And the State Department issues passports, of course, so heretofore it's been no is the answer. You're born in Jerusalem, you're not born in Israel. Well, Congress came along helpfully and passed a law saying that if somebody is born in Jerusalem and wants to say their birthplace is Israel on their passport, then that's the law, they can do it. All right? That's the issue in this case. And you can see constitutionally that this is the classic role, constitutional role of the Supreme Court. One branch, the legislative branch says A, the executive branch says B, who's right? Okay. So these kinds of cases that you see, they're taking fewer and fewer cases. They used to, back in the glory days, political days of the 70s, the Supreme Court would hear and decide over 200 cases a year. Now they decide fewer than 100 year after year after year. They're pulling their horns in, they're focusing on their business, and how you feel about that, I hope you'll share with me in questions and answers, but that is what he said he was going to set out to try to do, and I think he's making headway.